Hey, good afternoon, everyone. Thanks for joining. My name is Dr. Tibi. I am policy analyst at Tech Hive Advisory. And our events, the theme of our event is managing data subject rights. We're looking at the operational side of data subject rights besides what is contained in the Black Letter Law. So it's good to have everyone here. Welcome you to the webinar. Our speakers are already here, so we'll start very shortly. So Tech Hive is a technology policy and advisory firm. We specialize in a couple of things. We do data protection, startup advisory, emerging technologies, intellectual property, and we're also venturing into artificial intelligence and AI governance. So I'm very happy and very excited to have everyone here. This is a very important topic in the space. You agree with me that managing data subject rights is of utmost importance. Every organization needs to have a procedure in place for managing data subject rights. So this conversation is going to be as practical as possible because we have business owners here, organizations, data controllers, and processors who would want to know how to implement these processes in their organizations. So yeah, I'm very excited about the topic for today and our lineup of speakers. So I'll not want to be the only one talking. I'll let our speakers introduce themselves. So I'm not going to do the introduction on your behalf. I want everyone to hear from you. I know why we even selected this panel because I'm very excited about this webinar. So I would let our speakers introduce themselves, then we'll go into the conversation. So I'll start with Tayo. Please introduce yourself.
Hi, everyone. Hi, Dorcas. My name is Tayo. Please call me Tayo, is what everyone calls me. I'm a Nigerian lawyer, but I'm based in the Netherlands. I work in privacy. I've been in the space for a few years now. It's a real pleasure to be here to speak to the topic that we've chosen today. It's always a delight. I think I've been on a few of the sessions in the past with Tech Hive. We have a beautiful relationship. I'm also looking forward to learning from the very experienced co-panelists for today. So thank you for the invitation. Looking forward to a productive session.
Thank you, Tayo. We're very happy to have you in the panel today. So I'll give over to Ego Ibu, please.
Hi, Dorcas. Hi, everyone. My name is Ego Ibu. I'm also a Nigerian qualified lawyer living in the Netherlands. Tayo used to be my neighbor, fun fact. I work as the head of data protection for merchant services, global business line at a fintech. So as you can imagine, we deal with a lot of these requests. So data subject rights management is very interesting indeed. And I look forward to discussing with my co-panelists.
Thank you. We will look forward to hearing from you. Thank you. So Tolu, please, you can go.
Good morning or afternoon, depending on where you are. My name is Tolu. I am the Global Data Protection Officer and ISMS Manager at Paystack. I am not a lawyer. My background is more in information security and cybersecurity strategy. So it is a pleasure to be here. Thank you for the invite.
Thank you, Tolu. We're very excited to have you. I will look forward to hearing from you. Yeah. So we're going into the crux of the conversation. As I mentioned earlier, today's conversation is about data subject rights and how to operationalize data subject rights in organizations. So besides looking at what the law says, how do we make this very practical such that the data subject rights are respected in every organization? So to get feedback from our audience and also understand the conversation better, like just measure the level of understanding of what data subject rights are, we did a poll and the results were very interesting and is going to inform our conversations today. So I'll share my screen now. and then we'll look at the results of the poll quickly, and then we'll go into the conversation. So let me know if you can see my screen.
Yep.
Yes. So we did this poll and the question was about what challenges data subjects face in exercising their rights under the law. And the responses were very interesting. We had options or if they are simply unaware of their rights, or there's no procedure in place to exercise rights, or they typically do not get responses to questions or queries that they send to organizations, or if they know their rights but then simply do not act. And then the highest number of responses we received were data subjects who are unaware of their rights. So it was quite interesting for me. I don't know about you, but I found this very interesting because I know that data protection is still evolving, but that doesn't mean that we're not doing enough in terms of sensitization or creating awareness around data subject rights. And why is it that a lot of people simply do not know that they have rights under the law? So this conversation is going to be mostly as much as we're targeting businesses and how to operationalize data subject rights, to also try as much as possible to talk about these rights and see how we can explain it to our audience, and then get to a point where people now know that they have these rights, and then, of course, how to exercise their rights. So to begin, I would start with from the poll, of course. We see that a lot of data subjects do not know their rights. So we'll start from the basics. I would like Tayo to give me a brief analysis, or just what do you think the data subject rights are, in a way that our audiences who are not lawyers or who are lawyers but do not know about data protection would be able to understand what data subject rights are, and why it is now important to ensure that data subject rights are protected in organization, and there's also a procedure in place for them to exercise this right. Why is this conversation so important?
Thank you very much, Dorcas. I think indeed awareness may be perhaps the biggest problem when it comes to this topic. So what are data subject rights, or DSRs, as I will be referring to them subsequently from here? They are more or less legal rights that people have over the use of their data, right? So if an organization or an entity is using my data or your data for anything, especially if it has a commercial flavor, right? I do have some rights. I enjoy some rights that are protected by law. DSRs are the very foundation of data protection as a concept. So the concept of data protection is premised on DSRs. Data protection only exists in theory if we don't have these rights. It's the way that we operationalize, data protection. And what are these rights exactly? They more or less just seek to empower and give people control over how their data is used. It's a fundamental aspect of data protection. And one important point to note about DSRs is that they don't exist in vacuum. They are not abstract. They are not vague. They are clearly defined in the law, and they are protected by law. Just like we have the fundamental rights in the Nigerian Constitution, these rights also exist. So if you look at many data protection laws globally, look at some sections of these laws, you would find these DSRs captured right in there. The basic element or the basic essence, again, is to safeguard against breaches, data breaches, to avoid discrimination. Also, many of the violations that would ordinarily occur if these rights are not there. So the essence of these rights is to prevent against it. And what are these rights, in essence? What are they? Now, if you are using my data as a data controller of an organization, I have the right to be informed. I need to know what you're doing with my data. I need to know what data sets you're collecting on me, right? I need to know who you're giving my data to. I need to know how you're storing it, how you're deleting it. So this right of information is something that I enjoy. Also, if you have my data in your custody, I have the right to access it. I should be able to demand for the production of these data sets. And you have an obligation to provide it in such a format that I can easily read and even reproduce or share with other people. If you have my data in your custody, I have the right to instruct you to send this data set to other entities to use for a different reason. If you're processing my data, if you're using my data, I have the right to instruct you to correct if I have an inkling that you're capturing or documenting the wrong information about me. Let's say 5 years ago, you collected my data and I used to identify as Tayo. But these days, I want to start identifying as Ego or Tolu. I can instruct you to amend the information that you have in your database. Also, if the reason that you collected my information has lapsed, I can tell you to please remove my data from your database. And you have an obligation, or subject to some conditions, you have an obligation to immediately purge, these data sets. There are a couple of them. They are preserved in the law. If you go to maybe chapter 3 of the GDPR, you'd find these rights listed in there. Go to chapter 6 of the Nigerian Data Protection Act, you'd find these rights listed in there. So one important point to mention is that as an entity that is using people's data for whatever, you have an obligation to actually facilitate these rights. So if I have invoked this right, if I want to exercise this right, but I'm not doing it properly, there's an obligation on you to actually provide the avenue, the opportunity, the platform for me to properly exercise them. So you must support, in fact, at no cost to me, unless you think that I'm making a manifestly unjust demand for this right, or I'm trying to play pranks with you. So there is an inherent obligation on entities, on data controllers to actually help me, be able to enjoy this right. And one qualifier that I want to quickly, point out is that DSRs are not absolute. So the fact that they are contained in the law doesn't mean that I can just exercise them at will. They are still subject to some conditions. There are some conditions that, as a data controller, I can say no, I won't honor your request, because these are also defined in the law. For example, if you say purge my data, the data that you have in your custody, I want you to delete it. But there is a legal obligation on me to keep that data. I cannot process your request. I cannot honor your request. So they are not absolute. The only exception to this is that if I'm saying that I don't want you to use my data for direct marketing. So if you've been sending me adverts via email or any other digital medium, I say no, stop. That is the only data subject right that has no, it's absolute. There are no conditions to it. It must be processed. Very quickly, I want to speak to the significance of DSRs today as well. So again, remember that the essence of DSRs is to empower people and to give them control. So that's one significance. If people are aware and they know their DSRs, to a very large extent, they can determine the use to which organizations, put their data. So it basically gives individuals, you and I, gives us control, it gives us power over how our data, our personal data is used. And when that happens, we're put in a position to make informed decisions, better informed decisions. For example, if we're consenting to something, we understand what is happening exactly. So it's easier for us to give informed consent in that regard. And also with this awareness comes an increased sense of responsibility on data controllers, on the people that are using our data, right? Once they know that our people know their rights and people have these rights, they become more transparent in how they use data, because that accountability, that they owe us an accountability, they owe us this obligation to ensure that they are respecting our rights and they are processing it when we invoke it. So it increases accountability for data controllers as well. I would say another significance would be that it fosters consumer trust. So if I know that an organization is supporting or facilitating data subject rights, it's transparent about how they use their data, how they use my data, it's easy for me to trust them. It's easy for me to do business with them. And this doesn't apply to businesses to B2Cs only. It also applies to B2Bs. So if I'm dealing with a vendor and I know that this vendor is very transparent with how they use data and they're implementing safeguards to protect the data of their data subjects, right? It's easier for me to do business with them. I would choose them over other vendors that are not transparent or shady, even if they would cost me more. So that's one very nice significance of data subject, and especially in the context of the modern digital age. I will leave it at this point.
All right, Tayo, thank you so much for that comprehensive overview of data subject rights and the significance in a data-driven world, because the way data is being used on the internet and every other place it's alarming, and putting in place a procedure that will ensure the protection of data subjects is absolutely very important. And of course, it builds trust. Once you know that your rights are assured when you are using a particular service or a business, then you continue to go back. So that's very, very crucial. So you mentioned one very important point. You mentioned that organizations have the obligation to put in place a procedure, a system where data subjects are able to exercise their rights. And that has taken me to a very important point, operationalization of data subject rights. Because it's one thing to have it, and there's another thing to be able to exercise those rights. So I will throw this question to Tolu. What do you think are the systems or the technologies that an organization can put in place to ensure that data subject rights are operationalized within the organization and it is very effective, so that when requests come in, you're able to respond, and then you're able to accurately account for the responses, the requests that have come in, and then the responses that are going to data subjects. If you can provide a walkthrough of that process, then that would be nice. Thank you.
Definitely. I think what's important is to know your size. So you really should work according to the size of your organization. A lot of companies that look to take data protection, data privacy seriously, particularly in tricky areas like data subjects rights, if they have nothing in place, they will typically buy an elegant solution or something that's very mature, that needs and requires a lot of automation and configuring. But what people don't understand is you can just use a simple Excel tracker. Yes, it is a bit more manual, but it has the same effect. So if you're a company that's not very mature in terms of your compliance or a general privacy program when handling data subject rights, you may want to start simple. So what this may mean is just having a tracker, which one or two people are responsible, whether it's your customer service department, whether it's people within your privacy department, if you even have a department dedicated to privacy. So what happens is as you get incoming requests, you log them in the tracker. So you put the date of which it was received, where it was received from. Again, if you're a multinational company, you may want to put the country, because of course your obligations will differ depending on what jurisdiction you're operating in. And then of course know when you have to respond by. So typically we see around 30 days. Make sure you have that date of when is 30 days from when we received that date. And again, if you are using something like Excel, you can just have a formula that automatically fills in 30 days following the inputted date. Then, of course, you need to look at what type of requests. So as Tayo said, there are different types, different rights that data subjects might exercise. So again, just make sure you know which rights you're treating. And by doing that already, you have a relatively comprehensive view of incoming requests, when they need to be treated by, who is treating them, again, who's logged them will be the person treating them typically. And from there, you start to build your process flow. You start to build some kind of accountability document. So if any auditors or any third parties ask you, how do you handle data subject rights requests, you can automatically pull up this tracker and show over time, these are the requests we've received, these are the ones we've treated, etc.
Okay, thank you, Tolu, for that very comprehensive walkthrough. And so one thing that we understand is that laws are constantly evolving. There are changes and updates to regulations on data subject rights. So how do you ensure that when you have already put in place a system, it is compliant with evolving laws in that space?
Is that for me?
Yes, yes.
Okay. I think, again, if you're looking at different jurisdictions, or even if you're just looking at one jurisdiction, make sure you know exactly what that law prescribes. So whether you do this with your legal department, whether the privacy team is responsible, and again, if you have a dedicated team to handle data subject rights, whether it's within customer service or another team, they also need to be aware of what the law prescribes. Now, for those of us who aren't lawyers, when you look at law, it can be very overwhelming and a lot of legalese, and I don't know what half of this means, but you skip to the most important part. I'm sure most lawyers don't want to hear that, but you skip to the part that's relevant to data subject rights, and you look at exactly what it says there. So if you have a legal team that's gracious enough to help you, that's great. If you don't, it's really easy with data protection laws. You just go to the part that talks about managing, handling data subject rights and requests. And it will always say something about respond within 20 days, respond within 30 days, or as soon as reasonably, required, or without delay, without undue delay. So if you have a law that says without undue delay, then you need to figure out internally, what will our SLA be? Knowing best practice, you should respond within 30 days. I would recommend targeting around a 20 to 30 day timeframe. Of course, if you have a very hands-on customer service team and you are able to leverage some resources from that team to handle these requests, you can have a lower SLA of maybe 24, 40 hours. But again, that's where you come back to the tracker and make sure that that is locked, because yes, you have to respond within a certain time frame, but if they respond with additional information that you've asked for, you have to keep following up until the ticket is closed or until that specific request is closed. So when you're looking at complying with laws, it's always better to look at the small picture rather than the bigger picture and know exactly what you're focusing on within the law. If you're talking about data subject rights, focus on that. Look at what the timelines are prescribed by the law and act accordingly.
Thank you very much, Tolu, for that clarification. So you mentioned something about not being a lawyer and then having difficulty interpreting laws and complying with the same. So that would take me to Ego Ibo, who is a lawyer experienced in the space and has worked with different privacy teams, and also they have had to deal with a lot of requests coming in and out. So what do you think are the challenges that organizations face when trying to operationalize data subject rights as it is in the Black Letter Law?
Very, very nice question for me. So I'll start with what Tolu said. You need to look at what the law actually requires you to do. As you know, most laws are copying the GDPR, but with certain deviations. So the best practice currently as a standard is the GDPR, which specifies 30 days, but with a possibility for you to extend with another 60 days. But the issue is, whatever you decide, you need to notify the data subject as to what you're doing. So if you require an extension, you give that. If you require verification, you give that. So at every stage of the process, you update the data subject. Concerning global approaches to data subject requests, it's tricky because some jurisdictions say no, you cannot ask for more data in order to verify the individual, while some jurisdiction says, okay, you have to really ask for, you have to be sure that this is who the person says they are. So what do you do in this case? You need to consult the law. The law actually gives you a guide, whether in the recitals, whether in case law, whether due to guidance, right? So if you look at the case of the UK, for example, the right to privacy is not encoded traditionally in their laws, but this is something they inherited from the European law. So, and then through guidances and case law, they've established that individuals have the right to privacy. They have the right to exercise different requests, for example, deletion, rectification, whatever it is. So even if it is not in a statute, there's always an agency or the courts saying something about the request and how you should handle it. So, I mean, it's really up to you to define what is your standard, and then whether your standard meets the compliance requirements from that specific law. I find that it's easy to base your standard on the GDPR because it's the strictest data protection law in the world, although people say China is combating with it. But at the moment, it is easier for you to base it on the GDPR, which gives you a very clear guideline. It says 30 days and with what to do in certain situations. So then if you have a request, let's say coming from, I'm making something up now because I don't know what their law says. It's coming from India, which says without undue delay. Then you have to think, you know, what does undue delay mean? It's quite subjective. Undue delay can be 1 year. It depends on my speed. So if I say that I'm able to respond to your request in 1 year, then of course it is what I said. It's up to whoever is making that decision to convince the authorities. But if I were the authorities, I would say that 1 year is extreme. So then what you look at what the market, what is going on around the world, you look at other jurisdictions, for example, the LGPD, the GDPR with specified timelines, and then you say, okay, this is how we are going to handle it. Of course, there are deviations in requests from other laws where they ask you something not in the GDPR. So it's up to you to embed that request in your data subject rights management. So if the law is asking you, I don't know, to treat credit data specifically, like they do in the US. So when it's related to credit data from an agency, to treat it in a certain way, or if it is a HIPAA-related request, health data, to treat it in a certain way, then of course you need to comply. So for example, if it is the right to be informed, whereas the GDPR says, you know, be extensive, put it in a website or in a visible place or whatever, for HIPAA, it has to be clear at the point of collection. So if, for example, is a doctor, it has to be in the doctor's office in a very conspicuous area. So, you know, the requests differ according to what the law requires. But in general, I think we have come to a stage where data protection, the right to privacy it can be managed from a global approach.
Yeah, thank you so much, Ego, for that breakdown. So what do you think are the common challenges that an organization would face? Like the most common ones here when trying to operationalize this right?
I think it's so easy for us to say we live in a global world, but in reality, it's a headache, because then you are just seated in Amsterdam and you get a request from Bangladesh, and you're like, whoo, I don't even know what the Bangladesh law says. And then you need to start doing some research to see, okay, taking into account that this person is resident in Bangladesh, do I need to do something extra apart from what the GDPR requires me to do? So it's a constant battle to keep abreast of the different changes. And then you have also agencies that are constantly releasing guidelines. They tell you, oh, okay, so I used to think that you can do it this way, but I think now this is a better way because I've seen that you guys are not doing what we asked you to do. So the challenge for me is the resources to constantly stay abreast. So if you don't have some of these encyclopedia platforms where you can do research and constantly learn, you need to get an outside counsel that can always, you know, help you on these matters. Again, it goes to resources. You know, you need to get the management buy-in to get more money to, and then they're like, oof, data protection. You guys always just, you know. But yeah, I think the challenge is really the resources to really comply from a global scale. If you are lucky and you are doing business, you're not targeting, because this is how also the law looks at it. Are you targeting those individuals? So if, for example, is in Thailand, so they are based in Thailand, but you're not actively, for example, you're not changing your website's language to Thai. You know, you can argue that, okay, in as much as they use my service from Thailand, I wasn't targeting them. So it's a one-off. But if you actively go in there to do business, then of course you need to comply with their law, even if you're in the GDPR with the most strict law. So yeah, for me, it's the resources. And, you know, it's not just for the data protection people, but also for the organization. Because Tayo talked about consumer trust, yeah? I know some big tech that they are very good on data subject requests. I made a request one time, and the response I got, I was like, wow, this is marvelous, you know. So it's also about building consumer trust, and this is something that businesses don't realize because they feel like compliance is just a drag. They keep asking for things, but what is the value? The value really is compliance trust and consumer trust. And if you comply and they know that you comply with the law, people will come. So it's also a business advantage. You make more money. But again, it's something you need to sell to the board.
If I can make a very small addendum to that.
Yeah.
Ego spoke extensively to external challenges. External challenges can be, legal requirements.
I know where Tayo is going. Thank you,
yeah.
Tayo.
But I would like to speak to a challenge, to internal challenges as well.
Yeah.
And for me, it would be one very prominent one that I encounter on a day-to-day would be data mapping, right? So a lot of organizations do not have a comprehensive list of assets that host personal data. It's easy to get lost. I'll give you an example. I'm the global HR privacy expert for an organization that's in maybe 150 markets, right? We have hundreds of HR systems, hundreds. So every time you get a DSR request for deletion, for example, right, you have to purge data in every such system. So there's a lot of coordination. There's a lot of effort that's required to, coordinate between or among the system owners, because there are owners. Each of the systems is owned by someone in the organization, maybe a role in the organization. So you have to coordinate internally with all of them. Now the challenge is that if there's no real coordination, or you don't even know all of your assets, there's a likelihood of missing data or completing that instruction. So you may delete data in 100 systems, or the personal data of the individual that's requesting will still be in other systems. So if you don't map properly, you stand a very high chance. There's a high risk of not processing DSR requests completely, and that's a violation. So that's one internal challenge as well. I mean, training and awareness, employee training and awareness is another internal challenge that organizations struggle with till tomorrow. So I just thought to highlight what I would consider internal challenges.
Yeah, thank you. This is a challenge that is so prominent that I don't know, maybe Apple or Google, maybe they're at that stage where they know exactly where the data is. But a lot of companies have this challenge because of legacy systems. Maybe during the directive era, people were like a bit lackadaisical, but now with the GDPR requiring you to do this and that, with the Chinese law, Indian law, everybody is asking you to keep a clear register. It becomes even more problematic because you don't want to go in there and start wading into thousands or even millions of bytes of data. It becomes a lot. I've had issues where I tell them, why don't you just employ someone for 2 years? Like, let it be a temporary role, and his job is to clean up this database. Yeah, it's a challenge. But I want to also touch upon another challenge, which is dependencies. Like Tayo said, going to systems owners to ask them to do it. And hey, we have 29 days. And they tell you, all right, let me see before the end of the week. And you go back again, you say, we have 25 days. Oh my God, it's such a drag. People don't realize that chasing people to comply with this request is actually a job on its own. And it's so frustrating. At one point, I told one of my colleagues, do you think I enjoy chasing you? It was just annoying. So I don't know which is worse, whether it's the external challenges or the internal challenges, But thank you, Tayo, for touching up on that.
Thank you, Ego and Tayo. Like, I will literally relate to these challenges, and I think Tolu can relate as well. So I'm going to come back to you, Tolu. Do you have anything to add? Are there challenges that you have faced? I know you interface with data subject rights on a daily basis, and those requests come in like a lot. So how are you able to address these challenges internally?
I think I echo what both of my co-panelists have said. Specifically, one of the biggest thorns in my side is related to data mapping, but also related to follow-up. So it's a combination of the two. If we get an erasure request and the person has verified their identity, then it becomes an issue of, okay, we have this person's data. Which systems is it held on? You now look at all the systems, maybe one is a database, maybe one is a tool. So let's say we've identified at least 3 systems. Now we have to go to the owners of these systems. Now the owners of these systems may not necessarily be the person who will be removing that data. And can you even remove that data if it's on a production core database without affecting any of the other data? It's so we look at, there are a lot of nuances. And then of course, when you now aren't really sure, how can we remove this one piece of data without affecting any of the other data in that database? Of course, the engineers or whoever you're talking to is like, this is not on my list of priorities. I'll come back. So even if you follow up and you say, okay, we've got 28 days, people are thinking, and I have deadlines in 24 hours. So this is not a priority. So I found that has been quite challenging, but luckily that was about a year ago. And now we're at a place where, again, we have like a bot that if there is an erasure request, certain people who we now have identified are responsible for deleting that data are instantly tagged. They get a notification. They put a little check, tick emoji or whatever, or done emoji when they've completed it. And luckily, I've handed over the follow-up to somebody else on the customer service team. So they will just ping and say gentle reminder. But yes, those two things I would say are the biggest issues I face. But I'm lucky enough to have support and quality assurance externally so that I don't have to necessarily sit on people's necks. And I think because I sat on people's necks for so long, people are so tired of my follow-ups and they just do it anyway to avoid me coming back and forth, or it being escalated to me. So I would say, yeah, it's something that I echo has been an issue on both sides.
Yeah, I completely agree. I knew you were going to bring in that perspective, so thank you. So now I would like us to talk a bit about awareness, creating awareness. We've had a lot to say about internal awareness, training staff on handling data subjects rights, and then support on all fronts. So I want us to look at communicating data subjects rights. How do we ensure that data subjects are aware of their rights and then of the policies that you have internally on addressing data subjects rights? So, Tayo, if you can give us an overview of that, what do you think are the policies that an organization could have on data subjects rights, and how can they communicate these policies to data subjects so that they know that they have these rights and that there's a process in place for you to exercise your right?
Very well, thank you, Dorcas. So I think the best way to approach this question would be to start by distinguishing between external comms and internal comms. That's communication to internal stakeholders and communication to external stakeholders. Let me start with external stakeholders, right? So by external stakeholders, I mean people or data subjects that are outside of the organization. Now, the good thing is that this particular aspect is well regulated by law. So there's a provision in virtually every data protection law that if you are processing data, right, you must inform data subjects of some information. You must give them some information from the point of collection. So if you're collecting data with any tool, any platform that is public facing, on the interface, data subjects must be able to see some things about what you're doing. And some of the information that you have an obligation to provide include your identity as a controller. So the name of your organization, the identity of your data protection officer or someone that is the privacy rep of the organization, the categories of data that you're providing, what you're doing with the data, how long you're storing the data for, who you're sharing the data with. If you're sending the data abroad, you must include the details of that, the legal basis on which you're processing the information as well, the personal data. These are standard contents of the privacy notice. I mean, the tool that we're talking about in this context is a privacy notice. It's a legal requirement that organizations have to comply with. And how do organizations operationalize this? How do they do this? Sees that if you want to, if you land on the website of any organization, for example, you want to apply for a job, you have to go to you want to apply for a job at Philips, for example, where I work, you have to go to the career website. On the career website, you would find a privacy notice, and the privacy notice would have all of these requirements. So that tool, that instrument, is what organizations use primarily to communicate with external stakeholders, right? And there are different types. They come in different structures. There's a layered approach where you only see the header as summary. So if you click on the header, like, hey, what type of data are we collecting about you? It drops down, so you can read more information on that. When you click on another one, how long are we storing your data for? It drops down. So the essence is that you don't see the full length of the privacy notice. It's shortened. There are other types too. There's a dashboard type where organizations would actually give you the opportunity to make your privacy settings, customize your own privacy settings. So how they want you to use your data. Like if you go to, I think one very good example is the website of LinkedIn. If you go to LinkedIn now, you'd see that your privacy settings can actually be done by yourself. So they come in different formats, but in summary, the privacy notice is a tool that organizations use to communicate with data subjects externally. Now, internally, a different approach is adopted. The primary tool that organizations use is called a privacy policy. And simply speaking, a privacy policy is that documents that organizations use to inform their external stakeholders of how to handle personal data, essentially. So it's usually a very comprehensive document. It contains a lot of topics that just direct or provide guidance to internal stakeholders. And by internal stakeholders, I mean employees, interns, even management on how to use personal data. It contains everything that impacts on data lifecycle management, from the collection of data to categorization, to use, to sharing, to disclosure, further use, archiving, and even disposal, right? And there are some things that you also find in the privacy policy. You have issues touching on access management, how access is structured, whether it's role-based, whether it's rule-based, whether it's on a need-to-know basis, and all of that. It would contain information on asset management, endpoint devices. How do you use laptops? Can you take your laptop home? Can you work from home? And all of that. You can also find information relating to internet and maybe email use in the privacy policy. You would see stuff talking about reporting a data breach or consequences of even violating the policy. So usually organizations would post that policy on an accessible place, maybe a SharePoint or even on Conference, where employees can easily go and pull it and read and update themselves. So that's one way that organizations communicate with data subjects internally. Another way would be through awareness initiatives, like occasional. That is done periodically. You can maybe get an email from your DPO to just point you or quickly share a tip with you on what to do when you are confronted with privacy issues. Also, periodic trainings to maybe on a bi-annual basis or a quarterly basis. That's one way of communicating privacy policies or data protection practices. One other way of communicating would be in your employment contracts. For example, when you join a new organization and you get a contract, you would often find one or two provisions speaking to privacy practices in there. So that's one way of communication to you. Another would be the employee handbook, which is very comprehensive, but it's an addendum to your employment contracts, right? It would detail your obligations as an employee, data management obligations as an employee in there. So in summary, the primary ways of communicating data protection practices or data handling practices would be via the privacy notice to external stakeholders or external data subjects, and the privacy policy to internal data subjects.
Thank you very much, Tayo.
Sorry, if I could just jump in there and add something. As most of us know, yes, we do have biannual or annual trainings, which are required by law. But one thing that you can also do, because typically, depending on what your company does, you may have to do trainings for other topics, such as, I don't know, anti-money laundering, for example. So what you can do is use targeted trainings or lunch and learn sessions, awareness sessions with smaller focus groups. So if it's your marketing team, maybe do a targeted session on consent, and also what people may reach out to you for, such as data subject rights requests, even if it's misguided and it should go to a different forum. Having awareness within external facing teams, whether it's your marketing team, your customer service team, what have you, your general help desk team, having them know about data subject rights can either help redirect that query, or it can prevent misanswering such queries. So I think it is also important to have smaller focused sessions, and not necessarily training, but more awareness sessions, even if it's just 30 minutes, or even if it's disseminating this kind of webinar and saying, okay, this is something that these teams need to watch just to get an idea and understand the topic of data subject rights. That's all I wanted to add.
Oh, thank you, Tolu. You've even answered some of the questions that that I had coming up, because I was going to stress and maybe talk a bit about the importance of training and awareness internally, because one thing we've come to realize over in our practice is that a lot of people in organization, the staff of organization, do not know what their policies are about. They don't know how to even implement the policy, especially those with external facing roles where they have to interface with the data subject. They don't know where to redirect questions about data subjects, rights, and all of that. So I was going to ask Ego Ibo to tell us a bit about collaboration within teams. What do you think is the role of collaboration in managing data subjects rights effectively? And then if you can still add a bit of the relevance of training and awareness in ensuring data subjects rights are properly managed, then that would be very great. Thank you.
Thank you, Dorcas, for that. So indeed, I like to tell my colleagues that data protection is everybody's job. Yeah, in as much as I have the title, it's everybody's obligation. In fact, it's in our policy that it is your job to comply with data protection laws, to protect every information that we collect, to process it according to the law, according to our policies and procedures. So I often join a meeting saying that, okay, yeah, I know I have the title, but it's everybody's job to make sure that we get to the finish line. People don't, I find that in as much as the GDPR, I mean, there's a lot of noise over the past 5 years. It's not new. Everybody is familiar with the term, even if you don't know exactly what the law says. I still find that people don't understand in actuality how a request works. Yeah. So I come to you, I say, hey, we need to find the data in every system. Can you help me? And, Tolu mentioned it. They tell you, oh, sorry, I have a deadline. I'm sorry, I cannot help you now. And I'm like, hey, this is not up for discussion. I'm not here to ask for a favor. This is something you need to do, and I need you to get back to me in so and so time. Yeah. So you have to be pushy, but I think also this is where awareness comes into play, because I have some colleagues that over the past few months we work better because they know what to expect from me, and this is because I took the time. I said to them, hey, in a very pleasant manner, do you mind if we schedule a call with your team members so I can explain what my department does? So I go in there with my org chart and all the steps and where our policies are and all of that. So what exactly do we mean by data protection? You think like you have to go in there thinking these are teenagers and you need to explain the job, So I find that really worked. It works with so many departments across so many organizations because we are multinational. And I find that with those particular people, we work easier. But again, it's a lot of work. You have to really put in the work to go in there and to think, okay, where do I have my challenges from a practical point of view? Is it with the product guys? Is it with legal? Is it with security? Whoever it could be. Who do I need to speak to? Is it with sales? Maybe because direct marketing purposes. Maybe we get a lot of those requests for opt-out and they need to do it now because that's, Tayo mentioned it, is not up for discussion. If you are using marketing data, using data for marketing purposes, you cannot justify legitimate purposes. Oh, sorry, I cannot delete it. No, it's not up for discussion. So these are the different issues. And for me, I find that it requires multi-stakeholder participation for us to really, finish in 30 days. Okay, some requests may be complex. We need to extend it, but it's not a one-person job. It's not something the DPO can just go into the tool and do check, and we're done. So you need to really know your people. And I keep saying this, DPO role is a social role. You cannot be shy in this role. You need to be able to, speak before anybody. You need to be able to challenge. You need to be able to say no. You need to be able to say yes, depending on what the request is. You need to be able to know people in the organization, because if you don't know people, how will you activate a request? So you receive a request for deletion, and this concerns transaction data. You need to know, okay, I have to speak to the compliance, the financial security compliance guys to see whether this request that was collected, let's say 7 years ago, whether we still need to keep it. Because, you have certain laws that give you, according to anti-money laundering directives, give you certain ways, certain timelines for you to retain the data. So you need to know who to talk to. If you don't know who to talk to, you find out that you spend 1 week trying to find out who to talk to, especially in a complex organization where we have, I don't know how many entities across the globe. And if it is a request coming from a data subject that says, okay, yeah, it's India or it's Sweden, And then it's up to you to figure out which entity in India, because we have like 4 entities in India. If it's in Sweden, oh, we actually have 2 entities in India. Could it be this or this? So it's a social role. And this is why you need to keep also a list of who to speak to, even if it's not the main person, but that person will know the main person. So, and then you need to constantly speak about data protection. They need to see the passion. They need to see why it is important. And this is something you do, newsletters. I make it fun. I just keep it simple, 1-pager, you know, and then I say to them, please remember to visit our policies. Remember to take your trainings. Do you know that you can do Windows L just to lock your laptop? Simple stuff, but it goes a long way. And at the end of the day, it resonates with them. Yeah. So for me, I say that this job is for everybody.
So if I can just make a small addition to collaboration, right? I think this is one area that tooling is very important.
Absolutely.
I work in a very big organization. I lead the DSR process for HR, any HR related DSR process, right? From everywhere, like any market. And in this case, we're talking about what, because when we say HR, we mean employees and job applicants. Employees, we're talking about 80,000 employees. Job applicants, we're talking what, 600, 700,000 every year. So it's a whole lot. It's voluminous, right? So for us, as much as we can, we implement a lot of tooling. We use a lot of tooling, especially for collaboration. So when a specific request comes in and it has scaled through all of the hoops that we've designed, and we've actually confirmed that this is the DSR, I collaborate with stakeholders, other stakeholders within the tool, within the case management tool. I use service now. A lot of organizations use OneTrust. Yeah, on a very basic level, like Tulu said, you can use Excel, but when it becomes very complex, Excel cannot solve that problem. So you have to use like very comprehensive system. I use ServiceNow, and within ServiceNow, I can collaborate with other stakeholders. So as soon as I've identified where this is coming from, already there are triggers in their configurations within the system that I can easily assign to, hey, and as soon as I assign, SLAs start counting. So the owner of that process is getting notifications constantly too. So I don't even need to chase them around. If I won't chase you, the system will chase you. I don't have to do the chasing myself. You won't sleep because of the emails that you get, right? So, and there's
maybe I should do that with OneTrust.
I don't need to ping anyone. I don't need to ping anyone to send me an update. The system will do that for me. So that's if you send me an email outside of the system for follow-up, I won't respond. I'll tell you, hey, I need this. Because beyond collaboration within the system, there is also an audit trail implication as well, right? You need to keep an audit trail of what is done on every ticket, on every case. The conversations that are had, where you reach or who you reached out to, it has to be documented. And if you're having conversations outside of the system, if you're pinging people on Teams or on Zoom, you miss all of that. So if the regulator calls for that, let's say someone is not satisfied and they sue you in the next 2-3 years, and the person that you're chatting with, the person you're pinging has left the organization, it means all of that context is missing and it can put the organization in trouble. So I try to keep everything within the environment. So if you're pinging me, the assignment, me assigning this stuff to you is already documented. I don't need to. So to a very large extent, at a very high level, when it comes to DSR management, tooling is essential for collaboration.
Absolutely. I agree. I think with OneTrust is also very easy because you assign the subtask. For example, find the data in Salesforce. Yeah. So you assign subtasks to the stakeholders that you want to activate that request, and then you follow up. But the issue with that I find with sending requests is that I think I do it also with my OneTrust reminders. I just open a folder and I put them in there because like I get reminders on everything from the privacy risk assessment module to data mapping to DSRs. But in my case, I am always on that tool. So, I don't need to get a request to remind me to go to the tool. But I wonder now if people could also do that with ServiceNow, where they just discard the reminders, or put it in a folder.
Well, so the thing is that, and I think this speaks to a part of this conversation, is that it's an actual metric for us. We use it for performance evaluation.
Okay.
So if we check your SLAs and if you're exceeding your SLAs, it would impact on your performance. So if you're exceeding your SLAs by 100%, 150%, and so if you know that is being measured, it's part of your KPI. You don't want to exceed you will quickly jump on it. So we try to link that process to your actual
performance.
Performance. So it means that as soon as you see it, you know. I don't even need to tell you that the law says you should. You know that this is your salary, this is your job that you're playing with, right?
That's a very nice one.
So it's a KPI, and we measure it, we track it, we track and we measure.
All right, thank you, Tayo. Very interesting.
Thank you, Goibo and Tayo, for that wonderful insight. I didn't know about these tools before, so it's a very it's a very interesting perspective. So I would like to look to maybe in just a minute, you tell us about the strategy that you adopt in your organization to ensure that staff of your organization are aware of policies and procedures on data subject rights, and then how to effectively respond to these requests as they come in, since a lot of people are not aware of the existence of the policies and how to respond when they come in. Just briefly.
Yeah, so I think I mentioned earlier some lunch and learn sessions, some awareness sessions. So typically in the data protection officer's office, I try to at least once a month target different teams and sit with them, understand what kind of data they're using, because things change rapidly and people aren't always quick to notify the DPO or the privacy team.
Yeah,
I'll sit with different teams each month and use that opportunity to at least educate them on some key data privacy initiatives, best practices, data protection principles will always come up. And again, depending on the team and how much they relate or engage with external facing users or data subjects rights will come up in part of that awareness. And of course, I have a shared drive where all policies can be found, a shared knowledge space where everybody in the company can come and look at different how-to, whether it's how to respond to a data subject right request, how to initiate my own DSR as an employee. So that's what I do from an awareness standpoint. And of course, open door policy. If anyone has any questions, just hit me up directly and I'll answer them. In terms of how to actually respond to these requests, well, what we typically do in order to gain some time is have them fill out a form, because we see at Paystack, we have a lot of incoming requests from a bot. And I don't know if you're aware, there's a bot called Mine, which will send an email, which is automated and say, you know, hi Paystack, I want you to delete all the data you have on me. But because this is a bot, we need to be sure that this person really wants their data erased. So we'll respond because there is an email address associated with this bot from the user, and we'll have them fill a form to confirm their identity. This typically we don't get a response to, so that kind of closes the loop. Yeah. But when we do get a response, I'm sure Tayo would probably be so squeamish at how we do it. On my side, we do still use Excel, and that's mainly due to headcount. When you have different tools, and we do use OneTrust for certain things, but you need to be sure. My issue with tools is have someone who can operationalize and implement them. If you're not using a tool, especially a privacy tool or a unique, so privacy software management tool or HR management tool, there's no point using it if you're not using it to its full potential and its full capacity. So we don't currently have a tool for data subject rights requests, but if you, I don't know if I'm allowed to share my screen. Can I share my screen? So what we typically do, let me know and I can share my screen.
Yes, you can share your screen.
It says host disabled participant screen sharing.
Okay.
Okay, great.
Okay.
So typically what we do in order to respond to such requests is we have a script. So you can see here, this is the tracker. I know, Tayo, you're probably thinking you guys are in the Stone Age, but it works. For now, it works. So we have a tracker, which I won't show because it does have people's names in it. But here you can see this is a script. So we have for rejection of an erasure request, this is how we will typically respond. And you can see here, insert applicable legislation. And then we have the legislation here, the time frame. So again, this is embedded in a macro. So it's not like people have to come here, copy and paste. This script is already in a macro that will respond to the bot. And then it's just to fill in, you select which macros it garner, etc. So we have these for a merchant and a customer, for verification of data. So they're different scripts that you can use. And then of course, for the different data subject types, how does it work? For complaints, completed requests. So it's really just erasure requests. There are a lot, as you can see. So it's really just a way to house all the information. And for us, so you can see here, refer to the script. These are things, again, how to. So even if somebody who typically deals with these things has left the company, whoever comes up next can just kind of have a look at how do we do it? If it's an employee, how do we treat it? If it's a former employee, contractor, vendor, etc. And then again, refer to the script on which macro to select. And so it's for all cases, all different types of scenarios. Again, even if you're objecting to processing of data, etc. So yes, it is a bit clunky. Yes, it's not the most elegant looking solution, but it works. And the beauty of the way we do it is that part of it is automated. So it's not like somebody has to sit down and write all this stuff out. The automation is in Zendesk, which is what we use for customer service inbound tickets. So within that tool, we have any data subject rights requests. Sorry, I'm waiting for 1 minute, but any requests that come in of this type will automatically be pinged to a separate inbox. And then again, they'll be treated by the people who are trained, even though everyone on the team is trained. We, again, segregation of duties, making sure the right people are responding. And we do refresher trainings to make sure that they know what they're doing, maybe if new people want to join that team, etc. But it's important to have everything documented. So if anything fails, you don't have a key man risk. You don't have one person who's entirely responsible for the process. And as we continue to get headcount, continue to expand, we're lucky enough to work with Hive that helps with quality assurance. So as great as this system is, although it's clunky, we have Hive providing quality assurance to go and check all the tickets. So that's just a double, second line of defense and response to make sure that, yes, although these people have been trained internally, yes, there is a dedicated team to work through these tickets and respond. Because it's a lot of incoming responses. We get about 50 to 70, I think, a month for erasure requests. So it's a lot for 2 to 3 people to deal with, of course. So we have, thankfully, Hive who help provide that quality assurance. So it really is what kind of model works for your organization. If you are lucky enough to be able to implement a tool that will automate this, and you have people who are ready to collaborate on the platform, and again, that collaborative platform can link maybe to even the erasure side, then great. But if you don't have the resources to scale and implement a tool and have that tool be fully operational, because you need collaborators from different teams for such tools to actually work.
Yeah.
If you have that, great. If you don't, join me in Excel because it works.
So just to speak very quickly to that, I think you have a beautiful process to do.
Yeah,
If you ask me, again, based on your approach to DSR management should be based on the requirements of the organization. You just need to find what works.
Yeah.
And to add to that, I actually do use Excel myself, but it's a personal thing, right? I mean, for me, I want to make sure that nothing slips through the cracks. So beyond the system itself, I still keep an offline Excel document to capture all of that. So I don't have any problem. Again, different strokes for different folks, as long as it works.
Yeah, I find that is actually like Tolu says, is up to the scale of the business, right? So if you have the resources for it, why not? We use OneTrust because we have the audit trails, and Deloitte is the one checking all of that, yeah. But we also have the same workflow that Tolu has in automated form. So I build it per business line or per entity, and then you make a check, or it can be subject to an action. and then the person just gets the message. So it's beautiful, actually, what you have in Excel. I didn't realize that it could be just a
for us, the good thing is for us, we do most of the verification, the request validation. We do ID verification, and then actually have to validate the request. You need to be able to determine whether it's an actual DSR or not. Because sometimes people ask different questions, right? They ask sometimes it's spam, and like you said, most of the inquiries end at the point where you ask for validation.
90% of the case.
Right. But for us, I can't really track it in Excel because again, when you have a potential scope of 600 to 700,000 job applicants every year, it's a lot, right? And thousands of employees as well. So we get the volume is insane. So we try to use the system to filter as much as we can until the only thing we have to deal with is actual DSRs.
That is real.
So again, what works for you?
We're fortunate enough to have a lot of brilliant engineers at Paystack. So this Excel, it looks crazy. If I even showed you the tracker side, I think it's in the thousands possibly.
Wow.
But what happens is it's integrated with Zendesk. So as the tickets come into Zendesk, it automatically populates the Excel. So again, that reduces the amount of manual having to so it's automatic. Don't ask me how they've done it, but it is slightly elegant, although it will change it in a couple of years, but for now it's still working.
No, I mean, if it works the same as the automated tools, why spend all that money to get I don't know, OneTrust or ServiceNow? I mean, it looks really nice. It's the same process as what we have in OneTrust.
Even on ServiceNow, ServiceNow we have the templates, but for us we have a bit more flexibility because we have templates in maybe 24 languages, and we have different configured responses for every context. So whether we can't find your data, whether we deleted your data, whether this is not the data, there are like a couple of templates like that. So ServiceNow affords you that flexibility. It's such a nice system, and that is one of our 100 of the things that you can actually do, which is nice. So we use it for other things.
Okay, we use ServiceNow for responding to internal requests. So
we use it for everything.
Okay. Nice. I'm learning a lot, but Tolu, I'm interested in this Excel. Maybe I'll follow up with you later.
Thank you. It's been very, very interesting insight. So we see there are different ways of managing data subjects, right? We can go with the Excel or use more advanced tools like OneTrust, ServiceNow for managing data subjects, right? So it's very interesting to see that we can easily implement these things depending on the size of the organization. So we are closing now. We are coming to the end of the session. It has been very, very interesting so far. I've learned a lot, and I'm sure our audience, like, they have the same view about things. And there are a lot of questions, a couple of questions in the chat, and we'll be coming to the questions shortly, but taking final words from our speakers. I would like to get your view on how you foresee the landscape, the data subject rights landscape evolving in the next, say, 5 years, and if there are any best practices that you can recommend for businesses, both small and medium, large, on how to manage data subjects, right? So I'll start with Tolu.
Good, thank you. Because that's a great question, a tricky one. I would say what I expect to see is more bots that are coming out that are helping people. Say, if you sign up to us, we'll ping anyone who has your data and have them delete it. I think we're going to see more of these kind of bots surfacing. And I also think we're going to see a major shift in user awareness. I think I've seen that in different areas. Just me personally, I always, comfort organizations that I know aren't really handling data correctly, but also people who maybe aren't aware are becoming aware. And I'm seeing it more and more in certain it manifests in different ways. So we saw it recently at Paystack, where somebody wanted to sue, and I can say this because it was an incorrect complaint, but they wanted to sue for mishandling of data, how there was no privacy policy, but actually it wasn't us, it was the merchant they were dealing with. But because for whatever reason they came to us and they wanted to manifest this complaint, and they even started talking about supervisory authorities and how they can sue and this and that. So even if it's just to make a quick buck, I think we're going to see more people looking into this as a way of, I actually want to exercise my rights, and I also want to respond or hold companies accountable if they are not exercising my rights in the time period in which they should. So I think that's something that's going to come up a lot more over the next 5 years.
Yeah, I absolutely agree with you, Tolu, especially in this era of generative AI. You know, things are becoming even more complicated. We have people complaining that they asked an AI to create a CV, and they end up looking white instead of brown, or you know, and it's gonna come up. These complaints are going to be, it's gonna be massive in the coming years, and also considering that even for traditional companies, the banking sector, for, you know, like sectors that are traditionally very keen on, or not very keen per se, but very averse to engaging with new technology, they are becoming open to these bots because it makes everybody's jobs easier. You have bots that are answering the questions of the customer service without customer service actually doing anything. So you feed them the data, they produce it. But then we're going to have also challenges if you don't implement the bots properly. You know, people are going to start complaining. So I think with AI in particular, and the way things are going, people are becoming more aware of their data. The fact that, you know, okay, so I gave you this data, but you're doing something else with it. People, you're going to get more requests. You see those requests coming from every sector. People are becoming aware that, okay, so you collected it for a legal purpose, but are you also using it for other purposes? So I get those questions as well. I understand that you collected this for this, but tell me which other purposes, which other third parties? And I find that people are becoming more sophisticated. I'm like, whoa, look at you doing data protection. So it's going to get really, I don't know, the space will be more interesting. Also with these talks of who will be responsible for AI. Is it a risk officer? Is it a data protection officer? We don't know, but if they say it's my job, then give me more money, I will do it.
Yeah. So for me, what I foresee, and it's already happened, is the expansion of the scope of DSRs generally. I'll give you some examples, right? So let's take the right of access. The right of access is if an organization is holding data on me, I can request for copies, right? Now, if I ask for such, data, the organization has to produce the data. Now, in some instances, I've seen some very funny requests where the DS, or the data subject, would not only ask for copies of the documents or copies of their data, but would also ask for information relating to persons in the organization that they have accessed the data. So it goes beyond like a regular ask. Now, the position of the law is that you have to do a balancing act, right? Because as an organization, you also owe an obligation to your own employees. You have to protect them. They also have, privacy rights or data protection rights.
Yeah.
So you may not, based on, if you rely on that, you don't have to share their actual identity because you may be putting them at risk. So you can decline that request on that basis. But very recently in Finland, there was a decision that if the request concerns sensitive data, especially medical data, you have an obligation to actually disclose the identities of the employees that may have accessed that data.
Very interesting.
It's a new development, right? It's a new development and it's still peculiar to one or two markets, right? But that's an expansion of scope. And this thing is going to happen. I mean, with the emergence of new tech, with the rise of AI and all of that, it's one of the few expansions that we see. And you can see that the courts, especially European courts and regulatory authorities, are already charting that course. I don't know if you're familiar with Guideline 1 2022, came out last year, that really expanded the scope of right of access. For example, it's an EDPB guideline.
Yeah.
So it's not, access is not limited to what we know or what is in the GDPR or what is in NDP anymore. It's now very, very expansive.
Absolutely.
And I can see that trend opening up more in the future.
Yeah, I find it very interesting, Tayo, because I'm just wondering whether it's because it's special category of personal data and the fact that it's explicit consent, and don't forget the ethical, the UN
ethical implications.
Yeah,
we have to get creative too, actually. So
Yeah,
when we
yeah.
see that, instead of disclosing identities as an organization, you have to come down and say, hey, but there's still risk. I don't want
Yeah.
somebody to go and slap my employee tomorrow.
Absolutely, yeah.
So what we do is that we try to, because again, access is primarily role-based.
Mm-hmm.
The reason why you have access to an organization, to data within an organization, is because of the role, not because of your name.
Absolutely.
So what we try to do at best in such unusual situations is to disclose the role that, hey,
Yeah.
Tayo, not Tayo, but the global HR privacy expert, we have accessed your data in the course of their duties. So you have to get very creative. So,
yeah, indeed. Very good. I'm also thinking now, because we received a DSR request one time from a former employee asking for internal communications. And because of the confidentiality coming from the telecom sector, we cannot go into the tools to query the messages, because then we will be eavesdropping, So there are always nuances to this to this request. You need to look at it case by case, whether, okay, so what data is it actually? What is the scope of access? Yeah, I think this space will be, I don't plan on changing rules, I can say.
yeah.
Thank you very much for those interesting predictions. I completely agree. And the space is evolving, and we're going to see a lot more. And it's going to be much easier for organizations to manage data subject rights in the future. So there are a few questions in the chat. There's one question for Tolu. You mentioned something about challenges with managing data subjects. I mentioned data mapping. I think I also agree with you. So someone is asking how you can ensure completeness of data subject rights requests, complete fulfillment of those requests. If you have the challenge of data mapping, how are you able to reconcile the challenges and then ensure that data subject rights are attended to effectively?
I mean, the honest answer is you can never be 100% sure, is the honest answer. I know companies, the likes of Meta, have struggled with this. I know companies with billions of dollars of budgets who will never get it right, because unless you have started this process from the very creation of your company, you have visibility on every single piece of data, and you have documented that, and you audit that from the inception date of your company to date. And even then, human error. Somebody may have put something somewhere and not told you, or you may have been off. Like, you can never know. You can do your best, and don't let companies bubble you and say, we will give you complete visibility. You'll know every single piece of data that lies within your environment to an extent, because that day that you do that audit, or that day that you complete your data maps, and you know where every piece of data is, 1 second later, somebody could ingest a new piece of data and not look it. Absolutely. So you will never be able to. And even again, with the most sophisticated DSR procedures and all of this automated with tools and everything, there may be a system that's been left out of the loop. Now, that doesn't mean don't bother. It means do your very best, but don't let it cripple you to the fact that you're constantly saying, okay, person A has requested we delete all of their data. This is the data we have to keep in accordance with legal statutory requirements. All the rest we have to delete. If you can comfortably say you have, to the best of your knowledge, you've erased 100% of the data that is linked to that person that you can delete, that's the best you can do. But like I said, that's 100% of what you feel comfortable with is based on the fact that you have data maps, based on the fact that you have a retention schedule, based on the fact that you have a ROPA, a record of processing activities, based on the fact that your staff, people in different teams, people in the data team, or who are ingesting or acquiring data, are aware of these procedures. So again, there's no point building all these procedures, and then the people who are bringing data into your environment are there on a whim and don't even know that all of this is linked. So you can see there's the awareness part. Don't raise awareness on data subject rights in silos, in isolation. Do it and let people understand, especially people who aren't privacy savvy, let them understand how all of these different components tie together, and how, yes, we have a retention schedule. Yes, we want to delete data at this point. Let them understand how everything kind of fits into play in the bigger picture. So when I said smaller picture before, it's when you're looking at DSR by itself and operationalizing that procedure, but look at the bigger picture in terms of collaboration with other teams and having them understand why we need to know where our data is. And you can't do a data mapping exercise as a privacy office by yourself. You have to involve other teams. You have to involve, engineers, C-level executives. It has to be a company-wide process, the same way your robo is a company-wide process. Yeah, just get into the habit of raising awareness, and you have to start small. You have to. So nobody can expect anyone to ever get it 100% right. Some of the best privacy experts, a lot of whom are on this call, will tell you there's no solution that will tell you 100%. You can confidently say you've smashed this DSR and there are absolutely no holes, no risks. It's impossible. And that's why with data protection and privacy, you can never have 100% compliance. There will always be different iterations, different levels of maturity. It's depressing, but at least you can never really fail. You can never really win.
For me, it's do your best and do the rest.
Absolutely.
As long as you can demonstrate to regulators that you've done your best to comply. And I think the data protection laws also recognize that there are some provisions that say, hey, you need to be able to implement this unless it cannot be done technically. Unless you can demonstrate that you cannot implement this DSR technically, then you can say no, you can't. Right. So
I think we in data protection at least we forget that there is an important department that will make our jobs easier, and this is something I am currently advocating for: better collaboration with the data management team. Because like Tolu says, you don't know who is ingesting data, who is taking data out of a system to another system that maybe you don't even know existed. And this can only be done by this department, And I find that, okay, they say we are anonymizing it or we are pseudonymizing it, but you also need to go in there to see to what extent can they still link it back to an identifiable human being. And is this system something that is on our register of assets, right? So I see that not most, but a lot of entities are not having these CDO positions. They are more focused on the compliance aspect, forgetting that compliance needs the technical parts to work. Okay, so we work well with product engineers and the managers and the owners. That is great. But there is also a whole new sector that is doing a bunch of stuff with data that we need to become friends with. And this is where this is where the governance comes into place. Who owns the data from a practical perspective? Who is the custodian? How are they managing access? Right? Because then it could be that they give access to somebody and the person extracts the data and takes it to another platform, So it will be easier for a DPO to know that, okay, so everything is done in one platform and I have accessed this platform. I am sure that the data being analyzed or whatever is done in this platform. The issue becomes complicated where they get small vendors, it's just a vendor to help us with this and this and that. And then you ask them and you find out the vendor is actually being sent a bunch of data to analyze and give back results. So data management is such an important sector for data protection to help us to really have a complete register of processing activity.
All right, thank you so much for that insight. So we're hoping to still end the webinar at 1:30. So there are a few other questions. So I'll just quickly read them out, and hopefully we just address them in 2 minutes. In 2 minutes, yes. So one question for Ego Ibo. Someone is asking about the NDPA, and since you're vast with the knowledge of the law, I think you'll be able to address this question properly. The person wants to know how organizations can comply with the law, and it being that it's still new and there are a lot of complicated provisions there that are not clear and unclear. So they want to know how to comply with the law, and also if you can enlighten our audience on postmortem privacy rights, if that exists in our law at all. Thank you.
Thank you. Okay, let me start with the beginning, the first one. So before you can do anything, you need to do a gap assessment, yeah? So the gap assessment in that gap assessment, you try to identify the different domains of a privacy program. So it ranges from 15 to 20 domains. But here you find your policies and notices, and then you find training and awareness, you find data management, collection, processing, storage, you find DSROs, you find vendor management, the cross-border data transfers. So for each domain, you need to assess what needs to be done. So it could be that if you talk about policies, maybe you need to create new policies. Maybe existing policies are there and you need to review them and update them if required. It could be that for DSR, nothing has been set up. So you need to set up standing operating procedures. You need to identify what can I do to comply according to the law. So the first step for any data protection professional, whatever your title, is to do a gap assessment. And based on the results of your gap assessment, you now need to do a compliance readiness roadmap. Yeah, then you set up targets. I find people being very ambitious and they say, I'm going to do this and that in 6 months. And I say, well, okay, good luck with that. But to be honest, practically, you need at least 1 year to be ready. And when we say ready, you're not going to be 100% ready. If you're lucky, maybe you get to 60% and then you build up the remaining 40 over the coming years. But you know, it's something that takes time. So for me, you need to put in the work first to identify the gaps and then how to remediate them. Yeah. Now let's talk about post-mortem data protection. So actually my thesis was on this. It's such an interesting topic. So the law doesn't recognize the rights of dead people, right? And this is something that comes historically from the traditional laws, right? So we only protect the people that are living, that like living human beings. So I cannot go, for example, to say that, hey, my father had the right to be deleted from a platform. My father is late, and I'm trying to activate that right on his behalf. It's not something recognized under the law. However, in some jurisdictions, for example, with France, you see that the law recognizes the right to a good name, right? So if it's a case that has to do with defamation or something, then they're living their dependents, the inheritors, the heirs, whatever they're called, they can actually fight for them for that right to a good name. Then you come to the US, they have the right to publicity, right, which can be inherited, but it's something that is between intellectual property and data protection and not really a privacy right, right? So it's not something that is recognized. Data protection in most jurisdictions is for the living.
Yeah, no, thank you very much for that insight. I agree with you on that one. Post-mortem privacy rights are not recognized in our laws. So finally, with Tayo, there's a question in the chat box about data protection policies, and someone is asking the difference between a privacy policy and a privacy notice, and if you can quickly enlighten us on the acceptance of a privacy notice. Is that a thing? Should the privacy notice be made in such a way that data subjects are made to accept or reject it on websites?
So very, very, very quickly, I'll speak to this very, very quickly, right? So when you go to websites and you see what you see on the websites, right, it's privacy notice, it's external facing. You and I are supposed to see them. But what operates internally, what guides employees and management on how to use data within the organization is the privacy policy. So policy is inward, notice is outward, is external facing. Now, the essence of a privacy notice is information, communication. It's not a contract that you sign with users. Because remember that you can process data on different grounds. It can be consent, it can be legitimate interest, it can be contracts, it can be legal obligation. It doesn't have to be consent. So by asking people to accept your privacy notice, you're asking for their consent. And you may not even be processing on the basis of consent. So there is no, for me, it's bad practice really to put that checkbox that accepts privacy notice. It is bad practice because all you're supposed to do, all you need to do, all you're actually doing is communicating to data subjects your data processing activities. That's all you're doing. So you shouldn't be having accept or reject. But what you should have accept or reject should be the terms of use, which is very different from privacy notice. Terms of use is basically how you're supposed to use the website or the services of the controller and whatnot. So that is that. There is one question on whether companies can charge for data rectification and portability. The straightforward answer to that is no. Because remember that as a controller, you have an obligation to facilitate DSR. So it should be, at best, it should be free. And a lot of Nigerians already do data portability. If you port from MTN to, I don't know, to Glo, that's data portability. And it's free. I don't think the network provider will charge you for that. So they shouldn't be charged. But the only thing that you can charge for would be access. So if you are asking for copies of your documents, and if it is clear to the controller that your request is manifestly unfounded or excessive, if you're doing it maliciously, the controller can actually charge you for that. But when they even charge you, it can't be too much. It has to be reasonable. So if you're asking me for a copy of your CD, for example, I can't charge you 100,000 because it doesn't make any sense. It's not commercial. It's not fair. So the only data subject rights that the controller should be charging for would be the right of access, and it's on the condition that it is manifestly unfounded or excessive.
Thank you very much, Tayo, for that clarification. It's been an interesting conversation. Everyone must agree with me on that. And thank you very much for joining. Thank you for participating and sharing these wonderful insights. We really had a great time and we learned so much. So we've come to the end of our the session today. Just a brief recap. We're discussing managing data subject rights and how to implement procedures in our organizations to effectively manage data subject rights, and we learned so much on how to do these things. And interestingly, Tolu mentioned Tech Hive Advisory as a good place to come if you have issues managing data subject rights. We monitor and test your privacy program implementation and ensure that data subject rights are accurately accounted for in an organization. So it's something that we do, and we also have an upcoming webinar on Roundup on Data Protection in Africa, where we'll be discussing the activities of 2023 and then what to expect in the coming year in the data protection space. So I hope that you join that webinar as well. There's going to be a link in the chat box now. You can register for that event and then you attend. It's on the 12th of December at 12 p.m. And we'll go, of course, we're going to have a great lineup of speakers for that event as well. So thank you very much, Tayo. Thank you, Ego Ibo, for coming, for joining. It was a very interesting conversation. I learned so much. Thank you.
Thank you too. Thank you, everybody.
Thank you for the invitation and thank you, everyone.
Thank you.
Yes, thank you, everyone, for joining. Have a nice afternoon.
Bye. You too.
Bye.